Okay, welcome everyone. Sorry we were having technical difficulties there. Welcome to the April 2020 webinar for the MyHR Genius program with Thompson Co. It is this month we are going to talk about complex issues in wage and hour law. So last month, for those of you who listened or were here for the webinar, last month we talked about fundamentals of the Fair Labor Standards Act and fundamentals in wage and hour law, and laid a groundwork for this month's program, which is going to be talking a little bit more in depth. There's only so much, it's only an hour, so there's only so much we can, ultimately talk about here. But I think I've, put in quite a few topics that should challenge people or be a good reminder, at least, of some higher level wage hour issues. Since we are in, the period of COVID-19 and everything is COVID-19, 24/7 in the HR world, I'm going to try to, relate this. A lot of these issues are directly related to COVID-19 for HR, and a lot of them have application for HR as we look at downsizing and reducing wages and all of that sort of thing. There are a number of, whenever we're talking about reducing wages or cutting hours, there's a lot of wage hour complexities with that. So I think I should be able to talk about quite a few of them to help people out. So if you are new to the webinar series, this is me. I'm Kevin Mosher, and I'm a labor and employment certified specialist by the MSBA. I manage the office for Thompson Co. up in Minnesota, and run the MyHR Genius program nationally for the firm. And I am excited to have you on the webinar. If you have questions along the way, there should be an opportunity. I'll try to take a look at them and get to them as we go. But there's a little question feature, so you can type in those questions on there, and I'll, if there's a break, I will try to pull them up and take a look at them. If you are unfamiliar with the MyHR Genius program, especially during the coronavirus, COVID-19 era here, it has been, I think, quite resourceful for a lot of people on for members on the program. And you're welcome to try membership. It's a month-to-month, and it starts at $79 a month. Doesn't matter the size of your organization or business. And you can call our legal hotline for legal advice and helping with COVID-19 or anything having to do with HR, and you don't have to worry about legal fees coming along the way. So that is a pretty cool program, and it, like I said, has a hotline, and there's webinars and updates. We've done a ton of COVID-19 updating several times a week. We've done webinars on this. We've done podcasts. We've done primers. We've done a lot of information that we've been sending out to members on the program and clients. So, there's a ton that comes with the program for just like $79 a month. Okay, so topics that we're going to cover. We're going to cover more than this, but this will just give you a general feel for it. So we're going to talk about, last month we talked generally about the Fair Labor Standards Act and overtime and that sort of thing. We're going to talk about the exemptions from overtime. So we're going to talk primarily about the white collar exemptions, as well as outside sales people and the computer exemptions. So we're going to dive into that a little bit. We really didn't dive into it much at all last month, other than to just kind of talk about like what the obligations were for overtime pay and paying salaries and that sort of thing. We are going to dive deeper into the salary basis test. It sounds, commonplace but the salary basis test is complicated. And it's especially complicated when we talk about reducing wages and we talk about deducting from people's pay when they're salaried exempt employees. So there's a lot of nuances with it, especially in the era of COVID-19. So we're going to talk about that quite a bit. We're going to talk about travel time. We're going to talk about bellow plans. you might have never heard of a bellow plan. I'm going to talk to you about that. That might be a unique program that you might have some interest in. And so, yeah, we're going to dive deeper into all of these. And again, if you have some questions along the way, feel free to type them, and I will try to get to them. Okay, so the Fair Labor Standards Act, I am not going to get into all the state rules. Now, a lot of states have their own rules on wage payments, wage hour. Like Texas has their own rule, the Texas Payday Act. Minnesota has its own rule, the Minnesota, Wage Payment Act. California's got their own. A lot of states, New York has their own. A lot of states have their own wage payment laws. But I'm really, we only have so much time, so I'm going to focus on just what is the baseline at the federal level, because obviously, your state might have its own minimum wage. So, but at the federal level, the minimum wage is $7.25. Now, your state might be $10 or $11 or $12 an hour, but for a lot of states, primarily in the South, that minimum wage is the federal level. So $7.25 sets it for the whole country. That's just a minimum. If your state or your municipality has a higher minimum wage, obviously if you're doing business and you have employees, you're going to have to follow those laws. So it's going to be the greater of the two. But at the federal level, we're looking at $7.25. That sets the base minimum wage that you have to pay employees. Now, as a general rule, and this is like just overview, kind of catching us up from last month, but as a general rule, you have to pay all employees for all the hours that they work, right? So if they, quote, work, and work means like that they actually do work, not that they're taking vacation or not that they're hanging out collecting paid leave under the new, Families First Coronavirus, Response Act, the FFCRA, now that they're, that's not work, right? Work is actually physically coming in, doing work, picking up emails, pulling the lever on the machine. That's work, okay? So when you work, you are entitled to pay. As a general rule, employees are entitled to pay for all the hours, the time that they work. If they work more than 40 hours in a work week, and you get to define what a work week is. Everybody can have a different definition. Every business can have a different definition of what a work week is. But for the work week that you define, if they work more than 40 hours, you need to pay them at 1.5 times the regular rate of pay. Now, there are exceptions. We'll get into the exceptions. We all know that there are exceptions to this, right? And there are a lot of exceptions. But general overview, everybody's entitled to wages, minimum wage, for the time they work, and time and a half for any time worked over 40 in a work week. The restrictions on children, we're not going to talk a lot about underage work today, but then for all employees, unless you're exempt, you need to keep payroll records, certain information. They need to track the hours that they work. You need to track the rate of pay that they're working at. And you also need to put posters up. So if you don't have posters up at every work site, you're in violation of the federal law. So you need to get posters up. If you don't have like the laminated posters, you need to get those posters up at every work site. And it's not just the Fair Labor Standards Act that requires this. There are a number of laws like OSHA and that sort of thing that also require posters. FMLA as well if you have 50 or more employees. Okay, that's kind of review. Let's talk about the exemptions. Okay, so there are a lot of exemptions, and I'm only listing a few of them right here. The most common one that gives us the most heartburn are the white collar exemptions. Now, some of them are easier than others, right? And so when we talk about white collar exemptions, we talk about the EAP, the executives, the exempt executives, the exempt administrative employees, and the exempt professionals, EAP, executives, administrative, and professional, right? So that's what that means. There are also, under the white collar, there's also a specific regulation that carves out computer computer professionals, certain computer professionals, not just, help desk people are not going to be in this, but certain computer professionals are going to be exempt. They've got to meet some criteria. We'll talk about what the criteria is in a minute. And then also outside salespeople. It's not your inside salespeople. Companies routinely think inside salespeople who get a commission are exempt. It's not true. Inside salespeople are not exempt. There is a retail exemption for retail sales employees. That's not what I'm talking about. I'm talking about people that are like answering phone calls or that are even making phone calls out or taking phone calls in, or people who are coming into a showroom and and you're coming into a showroom, not cars, because cars are different, but if you're coming into a showroom and it's not the retail exemption, those are not outside salespeople, right? Commissioned outside salespeople are your typical like door-to-door salesperson that are going around. That's what the law was intended for. There are some nuances to it, but when we look at commissioned outside salespeople as exempt, we really need to focus. We want to think of it as people who are not in the office, people that are out there trying to generate sales outside the office. We'll talk about all these in a second. And then you've got some others. You've got the DOT. We sometimes don't think about this, but the DOT drivers, the reason you can pay people to drive by the mile is because those over-the-road drivers that are engaged in interstate commerce, they are, and they're like CDLs normally, but they don't have to be. They are also exempt. So that's why they have their like own rules, and they have their own hours limitation and all that. There is no hours limitation on how many hours an employee is at the max allowed to work under federal law. You could have employees working 24 hours a day. There's no limit on it. Now, some states have limits, like Illinois, for example, and Illinois is not alone. Massachusetts also has a law along these lines that is a 1 day off in 7, right? So you need, under a lot of these states, a number of states require that you give employees at least a 24-hour period of no work in every 7 days. Right, so it's a 1 day off in 7 type of rule. Now that's not the case under federal law. Under federal law, you could work somebody 24 hours a day. The only limitation is that if they're not exempt, which most people are, but we're going to talk about the exemptions here, focus on them. But if you're not exempt, you need to pay them overtime. Now in California, you have to pay overtime on the specific day. For hours work, more than overtime worked over 8 hours and then over 10 again, and the multiplier changes. But under federal law, it's just 1.5 times. It doesn't increase to 2 times if the person works 20 hours that day or 80 hours that week. It's just 1.5 times anything over 40 in the work week. They could work 24 hours in a day and then not work it all the rest of the week, and you would only have to pay them straight time at 20. In most states outside California, and there might be some other states that I'm not familiar with that also have that sort of like daily overtime requirement. But you could work somebody 24 hours in a day and under federal law and pay them just the straight time. And they would only be entitled to at least minimum wage. And if you want to pay them more, that's great. But they'd get minimum wage. And if they didn't work at all the rest of the week, they just get 24 hours for that week. If they worked because they didn't work over 40, they don't have to worry about the multiplier. Railroad employees, taxi drivers, domestic live-in workers, farm workers, these are all some other exempt categories. We're not going to really talk about them all that much. Okay, so let's look at the duties. So when we talk about the EAP, we need to focus on duties. So there are 3 tests that these white-collar EAP employees need to make. And most of you on this call are probably in the EAP, right? So most of you are either going to be professional exempt if you're a lawyer or maybe an accountant on the call. On this webinar, if you are an HR person, you could be either an executive if you're a manager or supervise 2 or more employees, or if you're not a manager but you're an HR person, you're probably an administrative exempt depending on what type of responsibilities you have. So we need to understand the duties, right? So there are 3 tests. There's the duties test, there's the salary basis test, and there's the salary level test. And so we have to meet all three tests. And it is the employer's obligation or responsibility, I should say, burden, to meet these definitions. If you are going to classify an employee as exempt from overtime and minimum wage and all those sorts of things, you need to meet all of these duties if you're going to claim them under the EAP. If they don't meet the salary level test, it's not going to work. If they don't meet one of the duties, it's not going to work. If you violate the salary basis test that we'll talk about in a minute, it's not going to work. They're not going to be exempt. You need to meet all, as the employer, it's your burden to prove that all of the boxes are checked, that all of the exemptions are satisfied here. Okay, otherwise the person is non-exempt and entitled to hourly pay and overtime and all that sort of thing. One other thing that comes up, just in case I forget, can you have an executive, a clear executive, or a professional or an administrative person who could be exempt, but you want to pay them hourly and pay them overtime? Absolutely. You can. The rule is everybody should get overtime. Everybody should be, if they work over 40, everybody should get at least minimum wage. If you want to go for the exemption, it's entirely discretionary. You don't have to. You could just say, look, we're just going to pay everybody hourly. That's fine. That's totally fine. Your CEO could get paid hourly. That is entirely appropriate. You don't have to. Okay, let's look at these duties. So executive, in order to be an executive, both of these need to be met. The person needs to manage or supervise 2 or more employees, and they need to manage a function or a business. The do they need, and this needs to be their primary duty, right? So when we look at the duties, we're talking about primary duties. Could the executive also do some other things? Absolutely. I guess I manage people. I'm also a professional as a lawyer, but do I do other things other than just manage people and work as a lawyer around the office? Yeah, I do. I probably have wiped down, desks and stuff to try to rid of coronavirus. And, it's not the primary thing that I do, obviously. I order some supplies for the office. That's an administrative task, right? That's not all that using all that much discretion or independent judgment. I order supplies. It's not management. It's not supervision. But at the end of the day, my primary duty is to supervise and manage the office. And if that's what I can say, and 2 or more employees, if I'm managing an office of nobody, I'm not an executive. I don't care how much your company pays the person. If you've got them in a lone office or they're working from home and they're not actually directly managing or supervising anybody, they're not a manager. Companies routinely misclassify people who they give the title of, like, for example, project manager. They're like, okay, you're a project manager. You've risen up. You are responsible for this project and all that it's related to. But do you actually directly manage or supervise 2 or more full-time? It's got to be full-time employees. And it could be, by the way, if it's like 4 part-time employees, that works too. It could be, but at the end of the day, it should be like the equivalent of 2 or more full-time employees. And so if you're just managing a project, that's not an executive. You're not going to be an executive. That's misclassified. Again, I don't care how high up the chain you are and how much money you make. You're not meeting the duties test. You need to directly supervise 2 or more employees. It has to be a function of the business. Okay, that's executive. That's actually not all that. Executives are normally not misclassified, except for the project manager example, because I do see a lot of project managers being misclassified. Administrative exempt. This one's the most complicated to understand. There have been hundreds and hundreds, probably thousands, of cases over the last 60 years messing around with the administrative exemption. It is complicated and convoluted, and it's really difficult to understand. But let's try. The administrative exempt is somebody who performs non-manual work related to business operations. They use it, so that it's got to be related to business operations, not the business itself, right? If I tell you HR is an administrative exempt category often, it's related to business operations, that makes a lot of sense. Marketing people makes a lot of sense. Accounting, finance people makes a lot of sense. Anybody part of operations, anybody under like the COO, we get it. That is supporting business operations. So often companies want to put people who do the actual work. They produce the actual product. They help produce the actual service that goes that the business does. That's not administrative work. HR is administrative. Marketing's administrative. Accounting's administrative. There could be others, for sure, that are administrative. Computer support could be administrative as well. But if you look at the job and if the answer is that this person is actually doing the work of the business, not in support of operations, then they're misclassified. Then they're not appropriately an administrative exempt person. That messes up. Sometimes it's really hard to tell, right? These are, I'm not here to give you like all the answers in life on administrative exemptions, for sure. It is complicated. I see situations all the time where I'm like, here's your risk. It's hard to understand, but we have to understand the job. We have to do the best we can with trying to figure out, is it related to business operations? Some, again, like HR, are easy to figure out. Now, not everybody in HR, for example, or in finance or accounting, or in computer operations is going to meet the second criteria, which is that they need to use independent discretion in matters of significance. If you have an HR generalist, or if you're on the call and you're an HR generalist, it depends. Every HR generalist is different, right? But you might not have independent discretion in matters of significance. You might just be taking in a lot of information and then going up the chain to ask for guidance on how to respond. That's not you making the call. That's just you gathering information and passing it on. People who, there are jobs, I don't know what jobs they would be, like customer service type people, who get calls in and then they just look at the menu. If you ever call government agencies are classic for this, right? So you call a government agency, a federal government agency especially, and you talk to a person and you say what the nature of your question is. Kind of like those little chat boxes that show up on government agencies. You tell them what the question is, they then search their manual and they tell you what. Then they auto-populate, or the person on the phone reads what the manual says. That's not independent discretion in matters of significance. Independent discretion would be an HR person who talks to somebody and says, hey, you know what, we need to do an investigation into this. Hey, we need to look at changing this person's wages, because they're out of whack, right? You're advising the managers, you're advising management on some changes because you're using your knowledge base and your expertise and you're coming up with some solutions and some recommendations. Doesn't mean you're implementing the recommendations, but at least you're a professional and you're looking at a set of facts, or you're doing some guidance. That's independent discretion. If somebody is ordering supplies for an office, and the supplies are a couple $100 a week, and they're like, okay, should I order Coke or Diet Coke? That's not a matter of significance. But if you're ordering supplies for Google's main office, and you're talking about thousands of dollars worth of Coke or Diet Coke, okay, that might be that's a little bit more of a matter of significance than a few dollars. So there's going to be, the same type of duty also might be relatively significant or insignificant depending on the nature of the circumstances. So we can't just paint a broad brush on all duties and say, well, that's not independent discretion, that's not a matter of significance. We really need to look at the specific situation and understand it, which is the job for HR people and lawyers to really look into this and dive deep and understand what the duties are. But that's what you need to do for administrative exempt. And I would just, again, both of those factors are really important. It messes up companies all the time. They overuse the administrative exemption, overuse of that exemption. That's very, very common. Professional exempt is also misused a lot. Not as much as the administrative exempt from my experience, but it is often misused. It is only for professionals. Your business might not even have any professionals, but it is only for those jobs that require specialized knowledge, and that specialized knowledge needs to come from a specialized degree. So I'm a lawyer. I have a specialized degree in law, okay? In case you didn't know that, lawyers have specialized degrees in law, so you probably knew that. So I've got a specialized degree in law. If I am going and helping out at a grocery store because, grocery stores are important during coronavirus and all that, I can't, I'm not a professional. My primary duty is helping out at a grocery store, right? Let's just say I'm stocking shelves, or I'm checking out, at the counter. So my primary duty is stocking shelves and doing checkout. I could be a doctor. I could be a lawyer. It doesn't matter. My primary duty needs to be, practicing law. It needs to be practicing medicine. It needs to be being a CPA. CPAs require specialized knowledge and training. Bookkeepers do not. Bookkeepers are rarely professionals. They might be administrative exempt, but they're pretty much not professionals. CPAs are professionals. Bookkeepers aren't. Paralegals are not professionals. Lawyers are. Right? So there's a difference in education. There's a difference in what because anybody can, not to belittle paralegals, but anybody can be a paralegal. You don't need to have a specialized degree. Not anybody can be a lawyer or a doctor. You need to have a degree in law or medicine, right? So it has to be the primary duty. Now, before I move on to the next slide, with all of these, especially with the executive, you could have a situation where, again, what is the primary duty? We have a lot of working supervisors, right? And I talked about it with my example of buying some office supplies, but you see it oftentimes in grocery store situations where the manager is jumping in and they're stocking shelves and they're jumping on the cash register, and that is totally fine. And they might even spend more than half their time doing that. But if the grocery store manager's primary duty is to manage or supervise two or more employees, that's their primary duty. That's at the end of the day, that's why they are a manager, even though they might do all these other crazy things all over the grocery store and fight fires and do all this stuff, because of, workload and needs and all that. That doesn't matter. At the end of the day, under federal law, if their primary duty is to manage or supervise or to be a lawyer, for professional exemption, then they're still going to meet the duties test. Okay. Outside sales. Outside sales, like I'd mentioned, I'm not going to, belabor this one. It's, I've kind of already talked about it, but it is think going door to door. Think outside the business. You have to be sending people outside to your customers, to your prospects. They shouldn't be, the customers, the sales shouldn't be coming in. You can pay those people commission, 100% commission if you want. You can pay them hourly, but most people get paid on a commission. And if they are outside sales, that's entirely fine. Otherwise, you have to pay them, hourly and track their time and all that sort of thing. Computer exemptions, computer people could often be administrative exempt. But you could also, if you're one of these jobs like a computer systems analyst, a computer programmer, or a software engineer, and the primary duty are these things listed, these have to be the primary duties, then you can pay them hourly at a minimum of $27.63 an hour. So given how much computer people make these days, that's probably not that big of a deal. But you do have the option of paying making this computer exemption if you're paying at least $27.63 per hour, and then still being exempt from overtime if you do that. But again, it only covers people that are doing the typical job, the typical duties that are associated with computer systems analysts, computer programmers, software engineers. It's not your help desk people. Most of the time, again, I'm just generalizing, but normally it's not your help desk people. It's not your lower level IT support people. It's your programmers, analysts, engineers. And again, those help desk people could be administrative exempt, but they're not going to meet the computer exemption. Okay, let's talk about the last two parts of the test, which are the salary level and the salary basis test. Okay, so the salary level test, that one's pretty easy. That just changed January 1. If you didn't know that, now you know, and you should make some changes. But January 1, the salary level went up to $684 a week. If you want to pay an exempt, call one of these white collar exemptions under, executive, administrative, or professionals, except for certain professionals, like lawyers, for example, don't have to be paid $684 a week, or teachers, or doctors. You have to pay most people though $684 a week, and it's not prorated, so you can't prorate it, and that's an important thing to know in the whole coronavirus time here, because you might be looking to cut hours for some of your exempt staff, and that's fine. There are limits on that, and we'll talk about it in a minute, and that's fine that you do that, but you can't go below $684. That is a hard floor. There's no prorating that. That's the salary level. You got to pay at least $684 a week. And then on the salary basis, it has to be a predetermined weekly amount. There's no fluctuations on this. Now, could you add to the salary basis? Absolutely. You could even track your exempt employees' hours and even pay them extra money based on the hours that they work. That is entirely fine. But you need to communicate to them that there is a base floor salary of at least $684 a week that they're going to get regardless of how many hours they work. If they work 1 hour that week, there are exceptions. We'll talk about the exceptions. But if they work 1 hour that week, they are generally entitled, or 15 minutes or 30 minutes, they are generally entitled to their salary, that predetermined amount of at least $684. They're generally entitled to that salary for that week that they work. If they don't work at all, no work, they're on, you want to call it furlough, I hate that word, but you want to call it furlough, that's fine. Call it layoff, which is more appropriate. You want to call it termination, which is entirely appropriate and accurate, that's fine. If they're terminated, laid off, furloughed, whatever, they're not working that work week. Again, you measure the work week, but no work, 0 hours that work week, they don't have an entitlement to pay, right? So that's an example. You don't have to pay them their salary level. No work for that work week, no pay. They work 30 minutes. They're entitled to at least $684 for that week. The salary basis is not supposed to fluctuate. Now, let's talk about exceptions, because there are going to be exceptions, because you're probably like, really? Like somebody's on FMLA, what about that? Okay, so there are a lot of exceptions. But the general rule is you cannot reduce somebody's salary if you are trying to claim one of the white-collar exemptions. Okay, exceptions. The first and the last weeks of work. That one's pretty easy, although it has come up quite a bit with the whole furlough thing. Furlough is a last week of work. Don't let anybody else tell you otherwise. Furlough is a last week of work. You're terminating that person's employment. It might be temporary, but you're terminating that person's employment. You terminate, you don't need to pay them. You can pay them, that's fine, but you don't have to pay them. Their first and the last week of work, they are only entitled for the days that they worked during that first or last week of work. That one's pretty easy. If they are absent for 1 or more full days with no work, for personal reasons, not having to do with sickness or disability, you can deduct the full day. If somebody has gone 1 day and 9/10 of another day, you can deduct because they want to go fishing, you can deduct 1 day. Not the 2 days, because they came in for that last 10th or last hour of the second day, and they showed up, and they're like, oh, fishing's over, here's picking up some emails, and they were in for half an hour. They're entitled to pay for that day. Could you take out of their PTO? Absolutely. You could reduce their PTO if you do PTO. But you could deduct from their wages if they take off a full day or more because of a personal reason. If they're gone because of sickness, you can make a deduction if it's in accord with a bona fide policy or practice. So for like work comp or sick plan, PTO, sick safe leave, whatever it is, you can deduct from, and they've exhausted it, and there's no more ability for them to get pay, you can deduct from their pay because they were gone for one or more full days, and you had a sick leave policy, but they used it all up because they were super sick, and there's no more sick leave available to them, then you can deduct for one or more full day absences. My experience is that most companies don't do this, but you could. If you want to offset for jury or witness fees, if you get some jury or witness fees or military pay, you could ask for an accounting of those fees from people, and the $30 they get to be a witness or sit on a jury for that day, and you're paying them the salary, and you because they worked that week, you pay them the salary, and so you pay them for that day that they're on jury duty in that week, but you can offset, deduct the $30 that they got in jury or witness fees. Again, theoretical, not a lot of companies do this, but you certainly could if you want to. If you want to impose a penalty for a safety infraction of major significance, and it's got to be pretty major significance on this, not just any minor thing, you could deduct from their pay for that. You could also deduct for disciplinary suspensions of one or more full days for a workplace conduct infraction. So if somebody, does a really bad job and they're a manager and they didn't follow, an OSHA safety guideline, then you could suspend them for 2 days, and you could deduct their salary for those 2 days that you suspended them. Sorry about the formatting on this. Okay, so on the salary basis, so let's talk about, we've already talked about a bunch of this. Let's talk about coronavirus with regard to the salary basis. Okay, so hang on, I'm just going to skip through this slide because looking at it, it's kind of annoying me. Okay, let's talk about coronavirus. So with the salary basis, can you deduct? It's very common right now. Companies are looking at cutting costs. They're looking at executives. You're hearing about it like every day. Pretty much that companies are cutting wages. You're probably looking at it for your company, at least thinking about it if you haven't done it already. Can you cut salaries for exempt employees? Absolutely, right? Just like you can increase salaries, you can decrease salaries. Totally fine to do. There are limits. You cannot decrease below the 684. If you decrease below the 684, that person's no longer exempt. And even if you cut them down to like 2 days a week, and they're just coming in 2 days a week, and that equals $400 for the work week because they normally make $200 a day. No, it's not. They're not going to be exempt. You've lost the exemption for that person. They've got to be at least 684. If you are reducing, let's just say you're reducing 1 day. You're going from 5 days to 4 days, and that's a 20% reduction, and you're going to reduce all the salaries accordingly by 20%. Can you do it? Yes. Again, it has to be at least 684 still. Can you do it? Yes. You can prorate and lower the salaries. You have to do it prospectively, so you can't do it in the middle of the work week. You have to do it and announce it for future work weeks. So like the next upcoming work week, you can do it. However, it is supposed to be long term, and I'm not telling you I can't tell you how many weeks that needs to be, but I can tell you that salaries are not to be played with, and they are not supposed to fluctuate. There's some guidance from the Department of Labor that indicates that the Department of Labor is going to be okay with it if you don't reduce the salary more than twice in a year. So if your plan was if you're just like, look, coronavirus is messing with us, we're going to go to 4 days, and then we might have to go to 3 days, and who knows, in 4 months from now, you're like, we got to go to 2 days, and you want to keep cutting the salaries, you're going to ruin, if you do it more than 2 times, you arguably are going to ruin the salary basis test and turn all of those people into non-exempt hourly workers. I would not recommend doing more than 2 fluctuations in a year. Salaries are supposed to be standard, and they're supposed to not be reduced based on the number of hours that a person works. And so the Department of Labor recognizes that, yeah, you can reduce salaries, but if you get into a situation where you're just moving salaries all over the place to understandably accommodate the crazy fluctuations in needs and the workplace, the Department of Labor is going to be like, okay, we'll give you a couple, but beyond that, it looks like you're just messing with people and you're treating people like hourly non-exempt employees, and that's what we want to avoid. So be very cautious when you're strategically thinking about making these reductions in people's salaries. PTO, you can use PTO to bridge salaries. One thing that we got with these new regulations that wasn't really as big of a deal all that much, when the regulations were talked about and it came out, but I think now with the whole coronavirus thing, I think it's a bigger deal, especially, in the hopes that things turn around and maybe by the end of the year, businesses will be back and there'll be some money to try to, give back and compensate these salary people that lost some money. So you do have the option of paying up to 10% in non-discretionary bonuses and incentive payments annually to kind of catch up. So if you are paying less than the $684, you could, at the end of the year, you could catch these people up. If you do dip below $684, you could catch them up. You can't catch them up more than 10%, but you could catch them up to 10%. So if you do dip below the $684, you can there is an opportunity for you to make up here. And then again, when somebody is on furlough, if the person's on furlough and they haven't worked at all that work week, they're not entitled to wages, and so you don't have to pay them their salary. Reductions can only, a slight nuance difference between deductions and reductions. When I talk about reducing somebody's wages by 20%, if you cut them back from like 5 days to 4 days because of, you're dealing with coronavirus or whatever, that is a reduction in the salary. You're basically telling the employee, show up, and if you hear the new terms, and if you show up that work week, you've accepted the new terms, right? It's like a unilateral contract. I'm going to reduce your salary. Here's your new salary. Your new salary is $700 a week, and I guess if you show up and start working, you're accepting it. So we need to, it's best practice to notify the employee in writing and put it in the personnel file and do all the change of status forms and all that sort of thing. But that is a reduction in advance. A deduction from pay is different, right? That's reducing somebody's pay because of like a garnishment or because of like they bought something, whether it's like a uniform from their wages or some sort of like authorization. Most states require that you get contemporaneous written authorization anytime you're doing a deduction. And this isn't just salary people. This is non-exempt people as well. This is actually probably more applicable to non-exempt because there is a chance that a deduction for like uniforms or some sort of other authorization that they give you, maybe meals. You might be charging people for meals if you're like a restaurant. You cannot reduce. As a general rule, you cannot reduce below minimum wage. So if you're paying somebody minimum wage and you make them buy a uniform, that's going to be a problem because that uniform is going to reduce their minimum wage. Their overall compensation is going to be less than minimum wage. That's going to be a problem. So you need to look at some other solutions and for that sort of thing. But deductions, most deductions except for like FICA and ERISA plans, like a 401k plan or group medical benefits, or garnishments, most deductions need to be authorized in writing by the employee, and it needs to be contemporaneous. A lot of that's a state law. Not every state requires that, but a lot of states do require that. And so you need to know what state you're in before you start making deductions from pay. Let's talk about travel time. General rule is that when somebody is traveling out of town, they get paid. I'm not talking about salaried exempt employees. If you're an exempt employee, we're not talking about you. We're talking about non-exempt employees that are entitled to compensation of at least minimum wage for all hours that they, quote, work. Travel for business is generally working time. That's hours worked. There are some exceptions, right? But if you're traveling and if you work 9 to 5, say you're a non-exempt employee and you work 9 to 5, Monday through Friday, if you are told, hey, go to this work site, travel over the weekend so it doesn't interfere with your work day, but I want you Monday morning at the work site in Milwaukee, Wisconsin, and you're based out of like Chicago, then that's travel outside of town, and that's travel to Milwaukee. And even if you travel on Saturday, even though you normally work Monday to Friday, and you travel on Saturday and you drive up to Milwaukee on a Saturday, that's travel time. That's compensable. That's working time. When we look at working time, we think of the schedule, 8 to 5. It doesn't matter what day. It could be Monday through Sunday. It's Monday through Sunday, even if they normally work Monday to Friday. So that person traveling to Milwaukee from Chicago, it's like an hour drive or whatever, they are entitled to an hour of compensation as working time for that drive. Now, they're not entitled to just hang out in Milwaukee, beautiful Milwaukee for the whole weekend, then go see the Brewers games, when the Brewers are playing and all that sort of thing. They're not entitled to, that's not working time because they're relaxing and they're having fun. But the drive up to Milwaukee is, and they're not entitled to like sleeping or anything like that over there. But the drive time is. Then they're ready and they're there on Monday and they're working at the other facility, and you don't have to pay them from the hotel to get to the new facility because that's a normal commute time, right? But you have to pay them for the drive from Chicago to Milwaukee, and then obviously the drive back from Milwaukee to Chicago. Now there are some exceptions. Let's just use my Milwaukee example. If you decide to hop on the Amtrak train, there is an Amtrak train that goes to Milwaukee from Chicago. If you decide, hey, you know what, employee, go travel on Saturday and do it after 5 p.m. And they take a 5 p.m. train and they get up to Milwaukee and it takes them an hour to travel by train. That's not working time because they're able to relax on a train. If they flew from Milwaukee to Chicago, they're able to relax. If they drive, they're not able to relax because they're driving. If they take a bus, they're able to relax. Those are all exceptions where if the person's able to relax and if the travel is outside the normal working hours, not days, hours, so after or before 9 to 5, and they travel and they're able to relax, that's not working time. We need to, when we have non-exempt employees travel, especially if they're traveling like really far distances, we want to try to arrange this as much as possible so that we're not paying them for travel time, because often that travel time then puts them into overtime rates so they could be, paid quite a bit. One thing you could do, and I'm not saying do it, but you definitely could do it, is just like you can set different rates for different jobs. You can set, janitorial jobs that get one rate and accounting jobs that get another rate and warehouse jobs get another rate. You could set a rate for travel time. So you could say, hey, as a company, if you're traveling, or hey, if you're traveling internationally even, we are going to set a rate for you. It's going to be minimum wage. So then you would just blend the rates and you would try to figure out what the regular rate of pay is, and you would blend the two rates, their normal rate and the number of hours, and it'd be a weighted average. So you'd come up with the weighted average to figure out what their overtime rate is when you're calculating any overtime that they earned that week. And this could save you a ton of money, especially if people are traveling internationally or they're traveling really far distances and they're driving a lot. You could save a lot of money for your company by changing the rate to at least minimum wage, for example. Again, just know that you have to take the blended rate. So let's move it into blended rate issues. Let's talk about regular rate of pay. When we talk about overtime, we talk about 1.5 times the regular rate of pay, not times the hourly rate. It's 1.5 times the regular rate of pay. Now, as a general rule, here are, all the things that come into the regular rate of pay. So like bonuses, commissions, anything that's not discretionary is coming in. Discretionary things, benefits, expense reimbursements, those are not coming into the regular rate of pay, but as a general rule, most compensation goes into the regular rate of pay. Here's how we calculate. Now, it's really easy if somebody is making a flat hourly rate and they don't have any extra money coming in. So if you're just an hourly employee and you're making, here's my example, $20 an hour, and you work 50 hours a week, that's $1,000, right? That's straight time. Well, there's an overtime premium for non-exempt employees because we're working 10 hours of overtime there, right? 50 minus 40. So 10 hours of overtime. So we take the overtime premium against 1.5 times, but we've already got the straight time calculation, so the 1 in the 1.5 is already taken into consideration. And so we just want to calculate the overtime premium, which is the 0.5. So we take the 10 hours of overtime that we've worked times the 0.5, the overtime premium, times the hourly rate of $20, and we find that there's $100. We add the two together, so the straight time plus the overtime, and it's $1,100. Pretty simple, right? You probably have online calculators, and your payroll company probably handles this. There also it gets a little bit more complicated if we throw in some bonus money. Okay, so take your example: $20, 50 hours, and in this situation, the person gets a $200 bonus. So we've got the $1,000 of straight time plus $200 bonus. Okay, so the regular rate of pay when we're calculating the overtime rate is going to be different. It's not going to be 10 times 0.5 times 20 because the regular rate of pay in this situation is 24 because we need to calculate in the production bonus. The production bonus makes it a $24 an hour regular rate of pay versus a $20 regular rate of pay. And so at 24, the overtime premium is 120. So you can see the difference between the two examples. It's a $20 difference. So not only did the person get a $200 production bonus, but that $200 production bonus gave the person another $20 in overtime pay. So it really ends up being like a $220 production bonus when all said and done. So at the end of the day, instead of $1,300, it's $1,320. So we need to always, calculate these in. And I know most people have payroll systems that do all this for them, but I still think it's worth knowing and understanding the math. Let's talk about bellow plans. I suspect many of you have not heard or know what a bellow plan is, and that's okay. It is, like it says, a strategy for limiting overtime in limited circumstances. It is only for employees that work irregular hours that vary, and the variation is out of your control, and it's out of the employee's control. That is to say, it is for a very select group of employees that work, in this country. You might have some employees in your organization, you might not. But if the hours are so irregular, we just don't know. There's no way to know. Like some weeks they work 50, some weeks they work 20, some weeks, the next week they might work 60, the next week they might work 35. We just don't know. What you can do in that situation is you can come up with an agreement with the employee, and you can say, hey, employee, I'm going to pay you a salary. This is where you can pay a salary to employees, and you need to track the time, but you pay them based on a salary. So you could say, for example, I think actually I give an example in the next slide. Oh, and by the way, you can't do it more than 60 hours. Okay, hang on. Let's look at the example. Okay, so here's my example. Coronavirus Sam. So Coronavirus Sam, we all know Coronavirus Sam, right? Okay. Works for a job with fluctuating hours. So we're going to say Coronavirus Sam is uncontrollable job duties and everything. Like we have no idea how many hours he's going to work. Okay, so some weeks he works 50 plus, other weeks he works 20 to 30 hours. It's all over. Sam's employer, Stay at Home Inc., wants to limit his overtime exposure because, sometimes Sam's working crazy overtime hours. He's gaming the system, but then it's like he's working under it. But because of the overtime premium, he's making way more money. So we come up with a plan, and we just say, hey, Sam, we're going to pay you just a straight 1,100 hours a week in salary, regardless. That's based on a 50-hour work week and 20 hours, a 20-hour hourly rate, right? So the 10 hours of overtime is at $30 an hour. You can see the calculation down below. So it's like $800 at 20 hours at 40 hours. So $20 an hour, 40 hours at $800. And then the overtime premium is $30. So for the last 10, so it's $1,100. Sam never works more than 60 hours a week, and he regularly works less than 50, and certainly less than 40. So that could work. Similarly, you could, so we, in this situation, we're paying Sam. We've limited our exposure for those weeks that Sam might work 60 hours. In those weeks, Sam's only going to get $1,100. But in the weeks that he works 35 hours, he's going to get 1,100 hours. So or 25 hours, he's going to get 1,100 hours. So we're going to pay him a flat salary. We want to do this bellow plan. It's not required, but it's recommended. It should be in writing, and it should be signed off and authorized by the employee. And again, it is only for limited types of employees and circumstances. So it's not the sort of thing that we want to, just do, all over. So anyway, if you are interested in that, definitely reach out to somebody at Thompson Co. or me, and we can help and walk you through and see if it's applicable for your situation. Okay. Lastly, interns. Interns, I bring this up because it is a wage and hour issue, because interns are often not paid, and that is normally incorrect. If you're a for-profit business, it is rarely appropriate to not pay interns unless they are coming through a school or other sort of training program, whether it's a vocational training program or a school training program. And there are all the questions and considerations. None of these are dispositive. These are all, we look at all these and try to figure out the economic reality of the situation to understand the situation. Nonprofits, it's easier for nonprofits to claim that somebody is an unpaid intern. But interns almost all the time, especially if they're like producing some work for you and they're not coming through a school educational program, and you're just like letting them be, and you're getting a benefit from it, but then they're also getting the benefit, but the benefit goes both ways. Then those people, those are employees. They should be paid. You can call them interns, but they should be paid. If they're coming through a school program and they're getting a primary benefit and they're getting college credit or high school credit or whatever it is for it, okay, that's a situation where that definitely sounds more like an intern and on a unpaid basis. And I think you have a better shot with that one. Okay. That's an hour of advanced wage. There's, lots more to talk about with wage hour issues. But that's what we were able to cover here. If you have any questions or want to talk about any of this, definitely feel free to reach out to me at kmosher@thompsonco.com. I appreciate the opportunity to speak with you today. Our next webinar will be in May. We'll see what coronavirus looks like in May, but it'll be on a physical ability, aptitude, and personality testing, and all the nuances that go along with that. So until then, take care, and I hope everybody is healthy, and feel free to reach out with any questions.